last but certainly not least, Elizabeth Rogers. Elizabeth, tell us who you're with and who you're representing today.
I'm a partner at
the whole thing will move.
It'll go.
Swing that thing.
There you go. Okay. I'm a partner with the law firm of Waller Lansden. Just opened an office here in Austin in July. Previously, I was with Simpson & Elkins for 17 years, and I'm not a stranger to this body. And I want to first say, you made such big fans when you met with us a week or so ago. I had my son involved in that meeting, and he said, she is the coolest ever. I can't wait to go
Would
back.
he tell my son?
Yeah, no,
because my son does not think
your
that way.
openness and your willingness to just hear us and to listen to us and then to conduct a hearing, this long. And I know that Representative Neistat, I know that all of you are like that, and I'm so impressed and I'm so amazed, and I just give you my heartfelt thanks for putting up with us to listen this long and to really get to the bottom of it. I want to start out, my practice is in the alphabet soup of MCOs, HMOs. I've had to learn that over 20 years ago. And I think that there's a risk of painting with too broad of brush strokes when we put monikers like that on certain business models. I don't know Cool Smiles. I know that the group that I represent, which is a coalition of DSOs, they're simply a contractual model. There's no ownership in anybody. It's just a contract between a dental group and a dental support organization that provides the back office support, whether it's, and these have been around in Texas for over 30 years, providing billing functions to marketing to everything non-clinical. What I would change in the description is to not say clinical support. It's actually the non-clinical, everything non-clinical that is under the purview of the DSOs. And there's nothing controversial about this. In every single relationship, and I hate to use ever and never as overstating it, but honest to goodness, every player in the health industry, if you start out, and I want to clarify, DSOs don't have anything to do with the managed care companies. They don't typically contract with them. The MCO, or the DMO, I think they call in this instance, Dental Maintenance Organization, they're the payer. They get the cap from the state or from the government, and then they manage that risk. That is not what a DSO is. We're also not a dental group because it's not, a clinical delivery model owned by dentists. It's simply a contractual relationship. And what I started to say is physicians contract every day with management services organizations. This is the same thing. This is a contractual, like an MSO, but just change the M for D, and it's a dental service organization. As far as the regulations and the statutes, I've been studying it like nobody's business since we were at your office, because I'm sort of new to the dental world. I represent hospitals, and I know all about physicians, and I know all about 501As. And I have to tell you, comparatively speaking, this statute and these rules are dense. The definition of the practice of dentistry goes on for a page. It doesn't just say hands on a hard body, health, delivering health services. It goes on and defines practice of dentistry as someone who would interfere with or try to control an independent physician's judgment. Let me also say that I disagree, and I think that there is full authority, broad-based authority. The board, by statute and by rule, has the broadest authority. I can't even give an example that's as broad as this. On one end of the spectrum, it's the board may adopt and enforce rules necessary to perform its duties and ensure compliance with state laws relating to the practice of dentistry to protect public health and safety. I mean, how much more power can an agency get than that that's regulating a healthcare license holder? The rules say the same thing. The board, their purpose is to safeguard the health and safety of Texans by developing and maintaining programs to ensure that only qualified persons practice dentistry and that violators of the law and the rules regulating dentistry are appropriately sanctioned. So I think that authority is there. I think, and I was listening to you, and you seem like Dr. Black, just a great guy and very nice gentleman. I was listening to
Really not. You obviously have not been around him very
He's
much.
very soft-spoken.
No. You have disappointed us.
Well, okay, maybe you're not, but you said that your concern is that the laws are just being winked at, and so what I'm hearing your concern is that it's an enforcement problem, not that we need to promulgate more laws and more rules. It is from that broad authority to protect the public health and safety to the narrowest authority that the board can ask for copies of these contracts. Do you know that the rules include, I counted 24 things that can and cannot be in these contracts? It's very prescriptive about what can be included in a management-type contract. I don't believe that the issue is more regulation is necessary. I think that what this body needs to look carefully at is how often is it being enforced. I'm just saying. I also want to say that
You're just saying.
You're just saying. I want to say that somebody held me to this standard 15 years ago. I know that Representative Neistat knows the name Joe Bill Watkins. He was one of my mentors in public policy, and I'll never forget one time saying to him,
We know Joe Bill.
I wanted a urge as a policy reason for one of the pieces of legislation I was working on that it would level the playing field, and he said, stop right there. That is shorthand for a competitive measure. And the legislature, that's not public policy. You don't want to go to the legislature and ask them to pass legislation to give one, an equal competitive advantage or a competitive leg up on someone else. And so when I hear level the playing field, at least from having been corrected way back when, I think look carefully at when it's discussed that DSOs provide the financing and the wherewithal to allow young dentists to practice medicine, to not have to buy the equipment from the retiring dentist, but it is otherwise made available to them through this contractual model. I mean, I think you have to look at that and see who may be disadvantaged by the model. That's what my ears are tweaked or perked to hear when I hear level the playing field. I want to also point out, and we can go through the book, which I didn't leave one for myself, that you have, and you can just see the various laws that are on the books, including, if you look at the very fact one on page 1, there's two rules or two statutes that sort of say it all in the middle of that page, and it's rules relating to the control of dental practice. And it says at the middle of the page, page 1, behind your 5 facts in the notebook, that the board may adopt rules relating to the practice of dentistry to prohibit a dentist from engaging in contracts that allow a person who's not a dentist to influence or interfere with the exercise of the dentist's independent professional judgment. But B goes on to say, but these rules by the board may not preclude a dentist's right to contract with a management service organization. So there's already express authority. The legislature at one time considered this and said, we're going to allow contracts between dentists and dental service organizations, and the authority for that, is expressly stated in the law. When you look at the tools available to the dental board that was mentioned, cease and desist authority, let me add subpoena power, the right to revoke, suspend, put on probation for a license, penalties. Did you know it's a third-degree felony for one to interfere with and try to control a dental practice? That you would turn over to the district attorney's office, and it would then become a criminal prosecution. There are numerous tools available to the dental board should it choose to exercise that authority against that act.
Elizabeth, I was just sitting here thinking, when you talk about that third-degree felony, I don't know, maybe y'all all have better luck with district attorneys really pursuing cases like that. I've had a few cases never pursued in my company, but having said that is maybe we should give some civil penalty authorities to the dental the board, that if a DA doesn't want to pursue that interference, we have a fine that gets your attention pretty good. And
it's there up to $5,000 a day.
That's not, well, $5,000 a day.
And every day is considered a separate violation. And there's another scheme for an alternate penalty.
Do you think we've ever, I want to ask, have we ever assessed that penalty? Well, you got to come up to this one. Come on up. We're just having a party at 7:45 on a Monday night.
I'm hungry.
I hope everyone filed their taxes before they came in today, because you're late, way late. This was your last day to file your taxes.
Okay, I'm Julie Hildebrand, General Counsel with the Dental Board. My understanding, the fine, again, we could refer to the AG and they could do that.
But y'all just can't do it? We
The
need
only
to get-
person we can fine is a licensee. That's the only person that we have. And when we say authority, I think we mean licensing authority, regulating authority. The only person that we can grab and do something with is a licensee.
And that's
We
exactly
can
the way the
refer.
medical board exercises this authority under corporate practice. They go after the license holder, the licensed physician. If there's a contract or a relationship that someone wants to say they're interfering with the practice of medicine, it is the license holder over whom the board exercises authority. I don't know that we would want to go to an agency regulating a vendor, a contractual relationship.
Well, I know you wouldn't know. I understand. You're paid to make sure you make that thing. I don't know. We're just going to have to look at how we simplify and how we get to the bottom of it without completely rewriting the Dental Practice Act. And
Can I just add one more thing?
please do.
In the healthcare relationships, if you look at Medicare, if you look at Medicaid, the government doesn't go down to the bottom of the chain and go after the contract holders. They go after that first-tier entity, the license holder. There's a thing in the Medicare program called the program integrity requirements, and the way they make sure that everything down the chain is going to happen according to plan, according to law, is by yanking the chain on that license holder, that first-tier entity.
Okay, and we've discussed this, and I think that there's some inabilities and maybe there's some vagueness. Inabilities to maybe enforce, and maybe we haven't given you all the tools with personnel and authority and board and engaged board, maybe not. I think there may be some vagueness that we could clarify, and I think that we'll spend the next 3 months trying to do that heading into session. Members, any other questions? Thank you all for coming.
Thank you.
Appreciate it. Well done.